I'm gonna
It's audio tape.
I'm gonna videotape you. Do you mind?
That's fine, as long as I never have to see it. That's okay. That's always the worst. So, my name is Devra Sigle-Hermosilla. I'm an attorney here in Ellensburg, and I do employment law. I do a lot of other things too here, but historically, throughout my career, I've done employment law with a focus on management side employment law. In the last firm that I worked in, Portland, it's all I did was represent employers. And of course, this is a hot topic. You know, how does the passing of the recreational use of not medical marijuana, in addition to medical marijuana, how does that change what employers are required to do under the law, what they should do, what they might anticipate in the future, how they should design their policies? It's been a hot topic, and it's been a hot topic since medical marijuana became an issue, and this just has heightened it, and I think is really pushing this very topic to a forefront. So what I'm going to talk about today, one of my colleagues, Paul, was going to be here to talk about the public sector. He couldn't make it because he had a training, so I'll talk about the public sector as well. I just want to let you know I'm not as familiar with the public sector as he might have been, but I definitely do know what I need to tell you about that, so it's important. And it's good that we have a mix of public and private, so I'll address both. And from the employee side as well, since most of us are probably employees as well as representing management. Okay. The first thing to think about and to remember is that recreational use of I always say medical marijuana. It's like, it just pops out of my mouth, so I apologize. The recreational use of marijuana is now legal. Everybody knows that. It was a big deal in Washington, but it is only legal in Washington State and Colorado. It's not legal under the federal law. And that is where a lot of the stickiness comes in as to how employers have to deal with the law. A lot of people, a lot of employees, they kind of woke up on December 6th and said, yeah, and they thought they could smoke pot and it wouldn't have any effect at all on their employment because it's legal. It's no longer an illegal drug, right? And that is where a lot of employees might get caught short-sighted and without a job, and maybe they wouldn't have smoked pot if they knew what the effect might be, or maybe they would and they would take that risk and they would need to do that. But my number one advice for employers is, once you have your policy in place, make sure your employees understand what it is, one way or the other. Because a lot of people don't understand how the laws are different. They don't understand the layers of laws between federal and state and local governments. The important thing for employers to remember is that the law that passed has absolutely no bearing whatsoever, technically, on what employers do. It had no mandatory changes. There were no optional changes. There was no addressing what employers need to do at all. And that's important because really is what that means is employers can continue on pretty much the same way that they did before with their policies, meaning you can still have a zero tolerance drug policy at your workplace. If you are a private employer, you can have a zero tolerance policy. If you're either private or public, you can have a zero tolerance policy if it's a safety sensitive position. So like law enforcement, public safety, things like that, which we'll address a little bit later as we go through. But sometimes the law lags behind what is practical and what employers are actually facing in their lives and in their businesses. So I think it's good to anticipate what some of the changes might be and to talk about what some employers are doing, what employers can do to protect themselves to achieve whatever level of anti-drug use at work or whatever policy that they want. Some of the ways that employers are dealing with this new law is treating marijuana use much the way that we treat alcohol use. They're both recreational, legal drugs now in Washington State, but they can have adverse effects if somebody is drunk at work or high at work or somehow under the influence. So that's a way that a lot of employers are just dealing with it. You know, if you're high at work and you cause an accident, then we have a problem. then we'll deal with it. If you smoke marijuana recreationally, I don't really care, as long as you're not in a safety position, as long as you don't bring it to work, as long as you're not selling it here, as long as it's not in our face, just the same way that alcohol, you're not coming back from lunch drunk, you're not coming back from lunch high. They'll treat it the same. For most private employers, that's probably the way that most people will address it. A lot of private employers don't even have a drug and alcohol policy to speak of anyway, so it would likely be treated the same way. The problem with that, obviously, is that alcohol doesn't stay in your system for 7 to 10 days, and marijuana does, potentially. So how can you tell? If somebody comes back from lunch drunk, they get in an accident, they're drunk, their alcohol level is going to tell you that they're drunk, that they were using right then, not that they were using alcohol a couple days ago or a week ago and it's just kind of still there. That's a tricky question, and it's something that the law enforcement is dealing with, and I think that the laws are going to be becoming more clear over the course of this year, because everybody has to have, supposedly, we know how that happens though, everything in place perhaps by next December, or this December. So we need to keep an eye on that. I would recommend that if for employers who want to follow the let's treat it like alcohol rule, that you follow the DUI rules for when is a person impaired, if that's going to be your measure. If a person is impaired enough for a DUI to get charged with driving under the influence of marijuana, then probably that's a decent enough standard for an employer to use to say they were too impaired to be working in their position under the law. So I am not a scientist at all. In fact, it's a miracle I passed high school because I had to take science. But I understand that there's some, and maybe some of the law enforcement related people in the room can kind of clarify this, but they're really developing a distinguishing factor when testing for marijuana that I think is important. It's important for employers to at least understand this conceptually, even if you don't understand the details. The test, there's two components essentially to to marijuana testing. One is THC, which I don't know what that stands for. THC, it's an active measure. That's the drug that apparently causes the impairment. And then there's the carboxy THC. Maybe I wrote these wrong, but it remains in the fat cells and it's in the system, but it doesn't necessarily mean that you're impaired or not because it's not the active component of the drug. I don't understand the details of that, but just understand there's two different measurements, and there's going to be new testing coming out, and if you are sending somebody for a drug test, you might ask the testing facility what they're testing for and to try to get it as close to impairment-related testing, not just use-related testing, if you have a more treat it like alcohol policy, okay? That's just an advice. And again, we can watch the developing DUI law. Case law will help define that. Some statutory regulations might come out. Some people are treating it still a zero tolerance policy, meaning we don't want any drugs of any kind in your system at all or in our workplace at all. If you're a private employer, generally you can say that. It doesn't matter if the person is in a safety sensitive position or not. Private employers have much more leeway under the law because they're not acting on behalf of the government, so there's no unlawful search by doing drug testing. And if an employee consents and says, I understand that if I want to work here, I'm going to be subject to these types of drug testing policies, there's nothing to stop you from testing them. And in that case, you need to make sure that your policies tell people this is a zero tolerance policy. That means that you cannot be impaired or have in your system or have on your person any drugs that are unlawful or controlled under state, local, or federal laws. Because if your policy is a little bit bare, before you could just say unlawful drugs or controlled substances, and that creates a gray area. Because what does that mean? Does that mean marijuana? Because now it's legal here, and I work in Washington, so you want to make that very clear. If you have a zero tolerance policy, that you are including all different drugs, and I would even say that includes marijuana because it is illegal under federal law still, When that changes, and if it changes, then that wouldn't be an issue anymore. Yes?
Well, if you use that definition, then alcohol wouldn't be covered. So
Well, you can say alcohol
You just
or
say
drugs.
it.
Right. Yeah, you're right.
Say it.
You can have a zero drug tolerance policy that doesn't address alcohol. Some people do, again, gray area, do define alcohol as a drug. So, but I mean, then what, caffeine, if we start taking all of those carbo loads or whatever. So it's just, the important thing is to define what it is that your expectation is. If you want to prohibit marijuana as one of the drugs that you're testing for and that you are excluding, you should make sure that you say no trace of any drug in your system that is a controlled substance that would be illegal or controlled under state, federal, or local law. If you don't say those things, then you're leaving it in a gray zone. And then there's room for litigation. And then there's room for the expense of having an attorney come in and fight about whether or not that qualified. Okay? So that's my recommendation. I am going to give you a sample drug policy. It's a sample for private employers. It probably won't cross over particularly well to public sector, which is why I notated private employers. But it's just an example, and it does contain some of those language I underlined that people are starting to update. That might be the only update that you do to your policy at all, and it's an important one. Yes?
The example, is that with the no tolerance version or the alcohol related version?
I have it under the zero tolerance policy. Yeah, because the alcohol version is more difficult, but in that case then you might say, you could take some of the language that's in the sample and say, we'll only test you if you have had an accident or reasonable suspicion that you're doing something wrong, which we'll talk about what is reasonable, or they call it probable suspicion or reasonable suspicion. What does that mean? You know, if you are only going to test people who are acting funny at work because you think they're impaired at work, the same way that you would say, oh, this guy's drunk at work, then you have to be able to articulate what that means. It isn't enough to just, and law enforcement probably knows this very well, it's not enough just to say, oh, they're high. How do you know? Are you a doctor? Did you test them? You know, you have to say their pupils were dilated. They were speaking in a way that's different than they normally were. They were stumbling. They smelled like marijuana. You have to define, just like you would. They smelled like alcohol. They couldn't walk straight. The same way. And so anytime that you're testing for any drug, even if it's prescription meds or whatever, if you want to identify someone that needs to be tested under the probable suspicion or reasonable cause test, define it. Don't just say, well, I thought he was drunk, or his supervisor said he came in from lunch and was drunk. Ask why. Talk about their behavior. There are checklists that you can get online. I have some. If you want one, you can email me or call me. There's a list, and if you're having your supervisors identify people who are drunk or high, most people understand what drunk looks like. A lot of people don't understand what high looks like. And so it's important to train people. What does it look like? What do the checklists say? Why do you think this person should be tested? And that's important, and you'll need that for your documentation, because I think that we're gonna see litigation, just like we did in the medical marijuana, which has even, you would think, more of a basis for, and that has its own legal issues regarding reasonable accommodation and so on. But it's still, this is maybe not even as defined as that, and there was a lot of litigation about that, so this is going to hit it hard. If you are in a union-related, if you're a union employer, you have whole other issues going on with that, because unions they're raring to go. I will just confess out loud that I tend to be anti-union because I usually represent people from a management standpoint or from an employee standpoint. So the union is kind of that third party, but I will give them this. Unions have pushed our laws to become what they are today. So we can watch what the union is doing, what is happening at the NLRB, what are employers starting to negotiate in their contracts with manufacturing, because manufacturing tends to be a safety-sensitive industry because they're operating heavy machinery, and those tend to be in public sector and even private sector, safety-sensitive positions that can be subject to pre-screening, which we'll talk about in a minute, and current screen, employee screening for drug testing. So that's important to note what the unions are doing. They are actively saying, we think this changes what employers need to do. The passage of this law changes everything. They're saying that out loud. And they're saying, we think that employees are entitled to use, recreational marijuana if it's legal, and just like they could with alcohol, and it stays in their system, and that's not fair. It's treated differently. And so I think that we're going to see some litigation about that. The Teamsters have actively said we are raring and preparing for litigation. So they're preparing in their battle to pick on someone who's going to be a test case, maybe a few test cases. So it's important to watch that. If you're in HR and you're defining what's happening in your industry, watch that, because that will start to push it. It may take a few years, but unions do tend to push the laws to go where they are today. Our whole federal, statute is basically pushed that direction. Let's talk about pre-employment screening, because that's an area that I do think has changed, perhaps, more than anything else. And this is particularly for safety-sensitive positions where you go, a person comes in and they say, have you ever used, marijuana in your life? Well, now it's legal, so to say, well, yeah, I used to, but now that I'm in the safety-sensitive position, I won't. That is starting to be more okay. So it's like you might have a 10-day waiting period to say, okay, we're going to hire you, but you're going to have to do another screen. If you were positive at that time, you're going to have to do another screen later to make sure that you're off of that you haven't taken it, and from that point forward, you'll be subject to random drug screening. Some employers are still saying, well, it's still illegal under federal law, and if we're hiring this person to uphold the law, then we still think that they shouldn't be smoking marijuana because it's illegal under federal law, so we're keeping our policies in place. I think that that's an area that might change. I think that that's an area that will be the first to go, is the pre-employment screening. So that's something to consider, especially if you're a private employer. You might want to just say, okay, yeah, you used to use recreational marijuana. That's fine. It's legal under Washington law, but now you can't because we have a zero drug policy. Okay, so that's an important change that is not required, but I think it's coming. The other area that is kind of an interesting one is if even if you don't have a safety-sensitive position, whether you're a public employer or a private employer that takes federal money, if you have federal contracts, if you have federal money, you have certain grants, certain types of those kinds of assistance from the government, whatever form that they might be, and sometimes you don't think of them like that, it's important to go back through your policies and make sure if you are receiving federal money or you're receiving a federal contract, what is required under that contract. Some people will give you grants, but they say, but you have to maintain a zero drug policy. Okay, you're subject to the federal Drug-Free Workplace Act. Okay, well that means that you have to make sure that your employees understand that marijuana will count as a drug under that because it's under the federal law, not Washington's law. All of the, Department of Transportation for obvious reasons, but even somebody who's not driving a bus and who is, maybe in a reception job that they're not going to run over anybody if they're high, still is subject to those laws under those contracts if they define it that way. Some don't, and you have to read the contract, and if you have federal contracts, it is really important not to take what I'm saying as the law and say, oh, she said we could do it just for safety sensitive. No, you need to read the contract, make sure what the contract requires, what the law requires that you do as far as your drug policies. Generally for public employers, we've talked about this, but I'm just going to recap. You can test for safety sensitive positions if you have reasonable suspicion, but you can't just do mandatory random drug testing of every position everywhere because you're acting on behalf of the government, and that is an unreasonable search under the Constitution, and that has been through lots and lots of case law that's been determined, so you need to be careful about that. Another area that a lot of people didn't know about, and this kind of came to the forefront under the medical marijuana litigation in Washington, is that even private employers who normally none of their people are safety sensitive or whatever, if they have a contract with a customer who requires their employees to be, the people working on their project to be drug-free, they can require that. And you can, even if you wouldn't normally care whether your person answering your call center is impaired or not, they do. And you can impose that requirement on your workforce. Private employers, of course. Even public employers, that's the same thing, right? If it's a federal contract, this is just a different scenario, but it's important to know. This is a case that was an important landmark for marijuana cases in Washington, and probably will be one that is cited very often in the upcoming litigation, is Roe versus Teletech Customer Care Management. Went to the Washington Supreme Court in 2011. The Washington Supreme Court ruled in favor of the employer because they had a zero drug policy. The reason they had a zero drug policy for all of their employees was because Sprint Nextel Corporation was contracting with them to provide call service, call center. So this is a bunch of people in a cubicles answering phones, right? It's not heavy lifting of machinery. But they were required to have a no drug policy. So the employer didn't really care, but their customer did. And so because of that, they were obligated, in order to keep that contract, to have their no drug policy in their workplace. Had they let some of their employees take drugs, including medical marijuana, they would be in violation of their contract. They could potentially lose their contract. That was considered a hardship, okay? And so that's an important thing to understand. This woman claimed that she was wrongfully fired from her job, answering calls at the call center. And after she tested positive for marijuana, she said she had permission, with medical marijuana usage, to work on her migraines because she suffered from migraines. And it was, legitimate. The doctor backed it up and everything. And the Supreme Court said no. The employer does not have to accommodate you if it would risk their contract with the private customer. So that's something to understand. In the policy that I'm providing, I do put that as one of the potential list, reasons that somebody might be tested. And the consequence, if somebody doesn't, you need to let people understand what the consequence of that is. If that's all you do, you have one customer, then yeah, they can't work there, under that contract. But maybe you have other places that don't have that contract. Does that mean if they refuse to test or if they test positive, does that mean they can't work on that contract, but they could work on a different case that is more like the alcohol policy where I don't take drugs at work, but I do smoke in my free time? What does that mean? So it's important to define that if you have different levels of requirements for your testing. Because if they had, this is where I believe that it would have come down differently and why it's important to distinguish that. If they had call centers, say Nextel, Sprint Nextel was this group of people, but in that bay it was AT&T, and AT&T didn't care what kind of drug policy you had. If you fired the person for this job for having, and they had medical marijuana card, or they had the ability to use it recreationally under Washington law, and your policy didn't have a reason for that, or was different, maybe they needed to transfer her over or do something different. So it's just, you have to think beyond just drug test, positive, you're out. You have to understand how it's going to impact you. Let me see. So that pretty much covers the most of what I wanted to talk about as far as the presentation goes. There's some points to remember that I think will help you in defining your drug and alcohol policies, which everybody should do. Should look at them. All of the ones that we used to put out do not say under state, federal, and local law. They just said illegal drugs. So right there, have to change everything. Any detectable, any detectable amount of marijuana in your system will be grounds for dismissal, or is it only the active portion once the testing comes back? You'll need to talk to your medical centers to make sure that what they're testing for, what it means. The courts do that. We look at I do juvenile criminal defense also, and we get testing results back all the time. And, you know, they break it down, what it contains and so on. Another thing to think about, and that reminded me of, not all marijuana is pure. I know it's shocking that that would be the case, but we're seeing a lot of cases of laced marijuana, laced with meth, PCP, cocaine, a lot of cocaine. And so that's something to think about. If your employee might be thinking that they're just innocently smoking a little weed on the side, but then they come to work and they've had enough of a mix that they've got cocaine in their system as well, how are you going to deal with that? You know, these are things to think about that I think we have only just begun to consider. As I was talking about before, these are points that you should follow if you're maintaining a drug and alcohol-free work program. Some of them seem kind of obvious, but when you're going through the process, it's really easy to forget these things, and it's easy to get caught shorthanded later. Keep written notes that objectively document suspect employee performance. That's the kind of thing I was talking about before. Talk about what they're actually doing, because that can be used as a basis for referral to testing. It can also support your case later if they try to say that they were just being picked on because they fit into a certain class of employees and you were discriminating against them. So it's important to document it well. And if your supervisor comes to you and says, I think that they're drunk, but they don't really have good documentation, send them back for documentation, okay? Just, you know, who, what, where, when, why, what's going on, and how is that different than their normal behavior. You have to understand your employees, you have to know your employees. Become familiar with their skills, abilities, and normal performance and personality, because that can be a change that you can document if you are referring them to testing. Again, become familiar with common symptoms of drug use. We've got alcohol down pat, we understand that. What are the other ones? You might even consider even going so far as meth and other things that you can identify if you're trying to maintain a drug-free workplace so that you understand what you're looking at. Document job performance regularly, objectively, and consistently for all employees. This way, you're not just picking on one person, you are documenting everybody, and you'll have a better basis for understanding if this person was doing really well, and then all of a sudden they're not, they're being lazy, they're coming in late, they're not motivated, whatever. Then you might say, oh, that's interesting, that correlates with December 6th. And then you might know what's going on. Take action whenever job performance fails, regardless of whether drug alcohol use is suspected. Don't only punish the people who are doing drugs or that you suspect of doing drugs. Treat everybody equally. If somebody's performance is failing, it's failing. Address the performance failure, and then if you need to address the reason behind the performance failure, whether it be a disability, whether it be drug use, whether it be just a bad day, or incompetence. Know the exact steps to be taken when an employee has a problem and is ready to go for help. One thing that the policy contains that I'm giving you is, it's optional, but if you have an EAP program, employee assistance program at work, if you have rehabilitation leave or medical leave that you would like to offer to people, to say, hey, if you need to get help, it's your choice, you need to go do it, but if you do, we'll give you a second chance. You need to make sure that they understand that and that you understand what that means. So if somebody comes back with a problem, they have to kind of self-submit themselves to that, but if you're going to fire somebody for drug use, and you have to apply this consistently, if you have a policy that allows it, then you need to let people know. And everybody, not just the people that you like. Okay, everybody has to be given that opportunity. If you go there, I would suggest that you look into what's called a last chance agreement, meaning when they come back off of their leave, that they understand that they're signing a thing that says, I won't take drugs anymore, I won't at work, I won't, I'll follow the rules or whatever, so that you can more easily get rid of them if they lapse and it's not going to work for you. Communicate immediately with your supervisor when you suspect a problem. This is for, supervisor to supervisor or even employees in the workplace. And have a witness to your actions when confronting an employee. That's just generally good advice anyway. Some mistakes to avoid when you are implementing and maintaining your policies. So if you go back through and you look at your policy, you want to make sure that it says what you want it to say. if you don't really need a total zero tolerance policy, and you don't really want to pay for random drug testing, and you don't really care because you're not having a problem with it, then you need to still have a policy in place that deals with what if you do have a problem with it. What if somebody does come to work impaired and it causes a problem for you? That you need to have that in place anyway. So reasonable suspicion would be the only testing, and what would you do if an employee was? So don't just ignore it. A lot of people don't have any policy at all. Somebody can come to work completely high as a kite, and you might not be able to do anything about it. You might be able to fire them because it's an at-will employment state, but if they're just not even breaking the law, again, that comes back to performance, and so it all comes together, and that's why you need to have a policy. Don't misuse the drug prevention program to disemploy employees for problems that are not related to the program. So if you have a person who has a problem with their performance, you need to address the performance first, and the drug is a secondary thing. Don't address the drug problem and fire them for using drugs when the real problem is the performance. Performance always wins. Let me just tell you that outright, unless you've got a union involved. If you have employees who are not performing and you fire them because they are not performing, you will have a stronger case than if you fire them for drug use, or you fire them for being, late. Well, being late can be part of performance, but just, some other reason that you have to go beyond, and it starts to look pretextual. It starts to look like you're making stuff up because you don't like them. So it's important. If their performance is failing any employee, then you need to document that and not be the nice guy manager that says, oh, they're all good, everybody's great, we love everybody. If somebody's performance is bad, it needs to be noted. You can still say nice things about them, but identify it. Again, same thing. Don't single out any employee or group of employees for scrutiny, because that starts to look like discrimination. An age group, for instance, or people with tattoos, or a certain ethnic group, or whatever that you think might be taking drugs together. That you want to make sure you apply things universally, because it can be a really slippery slope and look like discrimination otherwise. Have witnesses. We've talked a little bit about that. Don't just have a verbal policy. Don't just one day say, hey, everybody, new rule, nobody can have drugs at work. That's not going to work. You can tell people, but you need to have a written policy and hand it out so people know where to find it and so on. Again, don't offer rehabilitation selectively. Either you offer it or you do not, and that's it. And that's it. And don't promise people that you'll for sure give them their job back. You can say, kind of like with FEMLA, we'll offer you a comparable job when you come back, or we'll try to find a position for you, but we can't guarantee anything. It depends on how long the treatment is. But make sure that it's consistent, and you can have different levels. Management can be one way, and employees on the line can be a different way, but within each category you do need to be consistent. Always treat drug and alcohol together so that it doesn't get one-sided. Like we were talking about earlier, I was just talking about controlled substances. Well, some people get so absorbed with a controlled substance that they forget to even mention the word alcohol at all. So make sure when you go back through that you do address that. This is back to the unions again. If you are union, you have to be careful, because usually, the NLRA, the National Labor Relations Act, requires that certain job conditions, working terms and conditions be negotiated, and this can be considered, drug policy can be considered one of those mandatorily negotiated terms of your contract. So don't think that you can just implement it without making sure that it's okay with the collective bargaining agreement. And that's something to watch. So that concludes what I wanted to tell you as employers and even as employees about how employers are going to be affected by this new law. Does anybody have any questions? Yes.
If you have an employee that you need to leave the premises because they're impaired, does it have to say in your drug policy how that's going to happen? I mean, do I have to get them a taxi home? Am I legally responsible as soon as they walk out that door because they came to me impaired? I don't
You could be, yes. Actually, that is a good question. If somebody is impaired, probably the best thing would be to do is to call an ambulance.
An ambulance, interesting.
It depends.
They aren't gonna like to, no, they
No.
aren't gonna wanna respond to that, I don't
And,
think.
you know, I mean, but that's just to protect you. If they're
Rather
so
than
impaired
the-
that they
than-
can't drive, you could get a
Rather
taxi.
than the police,
You could call the police, you could call a taxi, you can call,
or if they walk, it's fine.
yeah, but then again, I mean, they could get
Yeah,
hit.
It's very, this is a tough one,
Yeah,
I think.
it is tough. I think probably a police escort would be fine. For one thing, it documents that you thought they were so impaired that they couldn't drive home, which helps your case. And it also shows the rest of your employees that you're really serious about this. And it protects you because, you know, you're not a tavern, so you haven't given them, but the same kind of ideas apply. If you have a dinner party and you send your people out the door drunk, that liability could come back to you. If you call them cabs, they get home safely, okay, but what if they don't get home safely and you called the cab and you gave the wrong address? I mean, of
It's
course
very
you
tricky.
could go on and on, but that way the police are used to responding to drunk and disorderly or whatever. You could call maybe I don't know if you could call a family member, that might just get too interpersonal, but if they have an emergency contact and they have given you a person's name to contact as an emergency, that could be considered okay, just like if they were having any other medical emergency, right? So that's something, but you're right, you don't want to let them just drive off if you know they're drunk. Because for two reasons. The legal reason, and they're both legal. One, they could get hurt and it could come back on you. But of course, we don't want anybody to get hurt. And second, it doesn't make it look very strong that you thought that they were so impaired that they couldn't do their job, but you let them drive home. It looks like pretext. It looks like you're picking on them.
Okay, thanks.
Anyone else? We still have 15 minutes. Let me hand out the policy. I'll probably come all the way around. And if everybody has one, we can just kind of go over and you can see some of the things I underlined under prohibited substances. We have underlined here federal, state, or local law, and we've also got alcohol there. But also we've got legal prescription and over-the-counter drugs. They can also be abused. If you have somebody who is abusing prescription drugs, you want to make sure that that's included in your policy. And even over-the-counter drugs, because people do weird things with over-the-counter drugs and it could cause an impairment. So you want to make sure that you put that in. Also,
Do your employees, they don't have to disclose what they're taking?
they don't have to disclose what they're taking in general,
Okay.
unless I think that you should have a statement, a policy that says that if it carries a warning label that indicates in mental functioning, motor skills, or judgment may be adversely affected, that they need to report that. I put in here to a supervisor, but maybe it's to HR, because then HR can talk about it, and it's a need to know. It's just like any other medical information. You don't disclose that to people. You keep it in a separate locked cabinet. You really are in control of it. You don't pass that around the neighborhood, but you might have to talk to the need to know people. The immediate supervisor, does this person operate heavy machinery? Is this going to be a problem?
Okay, I was gonna say.
You don't have to tell them, right. You don't have to say, oh, they're suffering from whatever. You just say they're taking a medication that has indicated that they could be impaired. Is that going to be a problem? You might, if it's a small course, treatment thing, they might go to light duty or a different job for the time being, or they might not be able to return to work until they are off that drug. If it's a permanent drug that they have to take forever, then you need to implement the interactive process, because if that, the accommodation process. So it turns into a whole different area of law. We've got inspections in here, that the company reserves the right to inspect employees, their possessions, workspaces. to enforce so that they understand that if they bring their stuff and their paraphernalia and their marijuana or cocaine or whatever it is to the workplace, that you have the right to look at their lockers, look at their stuff. That is pretty extreme, but if you're trying to prove your case, you want to make sure. Now, if you're a public employer, caution on that, because you don't want to be doing an unlawful search. So I would talk to your HR person or your counsel about how to do that properly. But private employers, you know, if somebody signs this, they've just pretty much signed all the rights away to it, and it's fine. And that's okay. That's what our laws allow. Again, drug testing, I included several. You may not even have all of these in the same